Thanks everyone for joining today's seminar. We have the pleasure of having Professor Jacqueline Peel of the University of Melbourne to present on the role of science in climate litigation and, importantly, its implications for both legal practice and liability. Just a brief introduction to Professor Peel. As many of you know, Professor Peel is a leading internationally recognised expert in the field of environmental and climate change law. Her scholarship on these topics encompasses international, transnational, and national dimensions, as well as the interdisciplinary aspects of law, climate, and the climate science relationship. Professor Peel is a Redmond Barry Distinguished Professor at Melbourne Law School and the 2024 Kathleen Fitzpatrick Australian Laureate Fellow, where she's leading a 5-year program on global corporate climate accountability. Professor Peel has also served as the inaugural director of the University of Melbourne's Climate Futures Initiative and was a lead author on Working Group 3 of the Intergovernmental Panel on Climate Change for its 6th assessment report. She is currently the chair of COP Universities Alliance, a collaboration of Australian and Pacific universities supporting the Australian government's proposed hosting of the UN Climate Summit in 2026, and will also serve as the coordinating lead author in the IPCC for its 7th assessment report. Please join me in welcoming Professor Peel.
For that kind introduction, that reminds me that I wear far too many hats and probably should be shedding some of those. Thank you also to the Institute for Climate Risk and Response for inviting me along today to do this seminar. I'm going to talk about climate litigation, but the focus is really on the intersection of science. And I think this is an interdisciplinary audience, so I'm going to try and keep it as terminology jargon-free as I can, but if I do slip into legal ease at some point, just let me know, and I'll reserve some time at the end for questions. Ben Newell, who was going to be here, sort of told me usually with these seminars there's a sort of 30-minute presentation and then some time for questions. That's what I'm working to. So what I wanted to do in the presentation today, maybe that doesn't work. I'll just do it manually. There we are. First, I thought I'd give you a little bit of an overview of climate litigation globally by the numbers. What this is, where it's happening, the numbers of cases, and just to talk through the ways in which science and law come together in this setting of climate litigation. And then I thought it'd be useful to go through how science has been represented and used and dealt with in some recent cases. Firstly, an international case. So we recently had the International Court of Justice, the ICJ, delivering an advisory opinion, which is a non-binding but very general statement of international law regarding countries' obligation to deal with climate change. I'll talk a little bit to that and the use of science there by the court. Almost coinciding with the ICJ's decision was a decision in the case of this was involving Torres Strait Islander plaintiffs suing the Australian government. Was ruled on by the federal court just a week or so before the ICJ decision. And just for contrast, I'll talk about a case called Parents for Climate Change versus Energy Australia. This is actually a corporate accountability case. And again, very interesting to see the way that scientific evidence was used to support the legal arguments there. And finally, I'll just reflect on some of the implications that I see from these decisions for legal practice, for the ability for establishing liability. So, a right to receive compensation, for example, or damages for climate-related harms, and more generally for scientific researchers who are entering or already in this space. So if we look at climate litigation by the numbers, this figure that's on the right is taken from the LSE Grantham Institute, which issues an annual snapshot on global trends in climate change litigation. So this is its 2025 snapshot. and figure 1.2 in that, which is just trying to globally represent, if you like, the density of climate litigation occurring across the world. Unfortunately, they did a design with this report for the first time ever, and the colours turned out maybe aesthetic, but not actually very useful from a scientific point of view in distinguishing different categories. But generally, when you're looking at that map, the colours that are towards dark pinks, reds, and purples are indicating a higher density of climate litigation. So more cases. And if you're looking at the blue areas or the yellow areas, that's less cases. So I realise you can't read the very tiny legend down the side. So what we're seeing at the moment is that there's around, and this figure is probably an underestimate, 2,967 cases globally that we can find across nearly 60 countries. And that includes more than 260 cases now in countries of the global south. So that's a new development, the phenomenon of climate litigation spreading beyond countries in the global north to the global south, and that's recent. It's really only since 2020 we've seen that. Over 80% of the cases are classified as strategic by the LSC, and by that they mean that these are cases that are brought with some policy or behaviour change goal in mind. They're brought to try and shift the needle on climate action. And they're often brought by environmental groups or other kind of activist groups who are trying to advance policy on these issues. About 20% of the cases, so 1 in 5 cases in 2024, targeted companies or corporate offices. Again, this is another trend that we're seeing. The original approach was that most cases were filed against governments, but now we're seeing a lot more cases filed against companies and a greater range of companies than in the past, not just fossil fuel companies, but also in different sectors. Australia, you can see they're represented sort of glowing red. This is actually normally in graphs when you see Australia represented glowing red, it's because we're a climate hotspot or a climate extremes hotspot. You might say we're also a climate litigation hotspot. We've had the second highest number of climate cases globally, and that's exceeded only by the United States, which is a far more litigious jurisdiction than Australia. So there's something going on in Australia that is producing this. Partly we think it's attributed to the lack of policy at the federal level on climate change for a decade or so of the climate wars, but also the greater level of climate risk that Australia is experiencing, and hence greater tangibility of the need to address climate change. And the final point that we note is that international courts that are operating at the global level really hadn't been involved in this space. All the action had been at the domestic level. But just in the last 2 years, we've seen a number of international courts issuing rulings. And why that's important is because they allow something to be said to countries on a more regional or global level, not just in the domestic courts of one particular country. So that's a really interesting development. So how do we see science coming into these climate litigation cases? So I've got 3 sorts of areas here that I think are really important, and they sort of are represented in terms of the most common through to the newer emerging kinds of linkages. So very much from the outset of climate litigation, science was very involved in providing evidence about the causes and impacts of climate change. So you'll often have scientific evidence presented to the court on those matters. That's become less and less a contested part of climate litigation, and these days the reports of the Intergovernmental Panel on Climate Change, its assessment reports, and particularly its 1.5 degrees report are emerging as a sort of gold standard. So what this often means is that courts will just pay deference to scientific conclusions in those reports and not really question the evidence that's presented. It's taken it that the peer review processes involved in the IPCC and the standing of those reports is sufficient to establish the scientific facts that we share. One thing that is interesting is that we're moving away from the sort of standard science in these cases being the sort of climate science around modelling and climate extremes to look at other aspects, including broader impacts of climate change on the environment, on ecosystems, on nature, and also on human health. So that's bringing in a greater range of experts into these kinds of cases. The second area where we're seeing a lot of action and an increasing level of action is the question that's put, that's often very relevant to a lot of these decisions about whether a particular event or impacts or increased climate risk can be attributed to a particular actor, project or activity. So it's about what is the causal link, evidentiary link between climate change as we're seeing it and say greenhouse gas emitting activities that are occurring from a particular project or activity or so this is the causation question that scientists often. And the final one that we're not seeing a lot of yet, but it's coming down the line, is evidence about how we should quantify the losses. So if we move away from cases that are just sort of challenging projects to cases that are seeking damages for climate harm, and a really important question is how we quantify those losses caused by climate change. Obviously, property damage and things like that from flooding or cyclones, that kind of thing, put a dollar figure on. But we're also interested in damage to ecosystem services, damage to natural environments, and in some cases, damage that is inflicted on Indigenous custom and culture. So how do we actually quantify those? What scientific kind of areas of knowledge and indeed Indigenous traditional knowledge come into these sorts of questions? So that's where we're seeing the linkages at the moment. And then I'll just go through some of these cases to give you a flavour for how science is being used and received in these cases. And I'll also just say something about how the law is being interpreted in these cases as well. So I mentioned that a very big development this year was the International Court of Justice, which sits in The Hague in the Netherlands. That's the fancy building that the court sits in. Delivered on the 23rd of July 2025 an advisory opinion on what obligations states, nation states have to address climate change. This is very long-running litigation. It actually started in a Pacific classroom in Vanuatu, where international law students there were set a question about what international law could do to address climate change. And they came up with the idea of an advisory, seeking an advisory opinion, and actually mobilised around that, first to get support from Pacific governments, including Vanuatu, and then all the way to the UN General Assembly, which put a resolution forward that states supported to actually put these questions to the court. So it's quite an interesting process to get to this point. One of the things that was really interesting about the role of science in this opinion was that the court actually requested and had a pre-meeting with experts from the Intergovernmental Panel of Climate Change. And speaking with some of these experts, they said that there was actually quite a lot of debate within the IPCC as to whether this fell within the mandate of the IPCC to talk to and advise the court about the state of the science. So it's an interesting kind of question from the IPCC governance point of view, because normally IPCC is all about policy relevant but not policy prescriptive, and they're interested or concerned somewhat that they might be veering into policy prescriptive in this kind of setting. But that meeting did take place, and it does seem that it was influential with the court in informing them about the IPCC science and the IPCC findings and reports. They are extensively referenced in the ICJ's advisory opinion, and essentially the court takes certain facts to be scientifically established. In other words, it's not going to sort of permit argument about those aspects of the science. It relied primarily on the IPCC reports, which were agreed to constitute the best available science on the causes, nature and consequences of climate change. Has to be said for IPCC authors like myself going into the 7th assessment cycle. This adds another layer of expectation, I think, on the IPCC that in fact, if it's a scientific standard in litigation context as well as in policy making context, that's quite a different challenge in terms of getting the, making sure that the assessments of the science are thorough, accurate, inclusive, and also not policy prescriptive, which is very hard in my chapter where we're in fact looking at policy. The court also notes that the term attribution, there's some terminology that's used that the court recognises is different whether you're a scientist or whether you're a lawyer. And according to the court, it kind of says, it sees attribution as it heard it from the scientists as meaning the ability, I'm just going to, probably so I can see my notes probably. In terms of the science, it was about being able to show the linkage between attribution of an event to climate change, particularly like an extreme event. Could you draw a line between greenhouse gas emissions and a particular climate impact? In a legal sense, it was used whether you could draw a nexus between the activities of a particular country and harms that were occurring. So it was less about the event and more about being able to hold someone responsible for those activities. So switching to a very different case, this is the Provide litigation. As I said, it was pretty much the same timing as the release of the ICJ advisory opinion, just a week or so before. And this is a case that delivered in a legal sense a very disappointing result for the plaintiffs. The plaintiffs included Mr. Pabai, Mr. Paul Kabai, who are represented on the slide there. They're Indigenous elders from the Torres Strait Islands. They're representing their communities on the basis that they were concerned that the Australian government was not doing enough to protect their islands from climate change. They are seeing very real impacts on their islands. And they also made an argument that the Australian government both needed to do better adaptation to protect these islands, but also needed to do more on mitigation, and in particular to introduce emissions reduction targets that were based on the best available science. So even though this decision has a rather unhappy ending, the plaintiffs in this case were not successful, it is a really interesting decision in terms of the use of science and this whole question about what constitutes the best available science when you're setting emissions reduction targets. Very long decision. And this meaty bit is in the middle. So if you just read the front and the end, you won't get any sense of the. One of the sort of aspects of this case was that there were a number of eminent scientists called as expert witnesses for both sides. You might be aware that Dr. Andy was one of the experts called. Professor Pittman, Professor Caroli, who's emeritus professor at University of Melbourne, Malte Meyenhausen, and others. So it was pretty much a sort of mini IPCC that was presenting to the court. And the court also, like the ICJ, like the International Court of Justice, found that some facts are basic and uncontentious, ineluctable, that's a very legal word to use, scientific facts can't be challenged. Around the anthropocentric causes and unprecedented changes associated with climate change. I really like this paragraph in our current political context, paragraph 211, where the court said the basic science of climate change is now effectively uncontroversial and indisputable. It's only disputed by those on the very fringes of the scientific community, or those driven by nakedly political, commercial or personal agendas. I'll leave you to decide into which category our coalition politicians debating net zero fall in the current context. The court talked about this concept of best available science and in effect accepted Professor Caroli's evidence that really that was the IPCC reports as sort of reflected or added to by some of the reports of the United Nations Environment Programme, for example, the emission gap reports and certain Australian government reports, particularly on the state of the climate. So those sorts of things represented the best available science, which the applicants were arguing needed to be the basis for emissions reduction target setting. Professor Meinhausen particularly focused on carbon budgets and fair shares. So looking at the global carbon budget, trying to come up with different approaches for how you'd allocate that across different countries, and then using that to reach a judgment about whether Australia's emission reduction targets were scientifically based. And essentially the court did get to the conclusion that early emissions reduction targets that we had in Australia under the former coalition government, so our early targets taken by the government of Prime Minister Abbott, Prime Minister Morrison, did not meet that standard of being in line with the best available science, and in fact had been set on a totally different basis with lip service to the science but no real consideration of it. However, the court wasn't convinced that our current 2030 target, the 43% reduction below 2005 levels, could be said to not be based on best available science. So it was at least arguable that science was taken into account. The court also said target setting is one of those areas where it's not all about the science. In fact, the science is one consideration, but the government takes into account many other factors. And in fact, it said that this is a matter of high policy and political judgment. So it's not really appropriate for the court to look at this at all. And that's really why this case failed. It wasn't a failure of the science, it was a failure of the law. And the court set that out very clearly in this last paragraph. I'll sort of paraphrase it, but essentially the court said that the applicant's case against the government failed not so much because there was no merit in their factual allegations concerning the government's emission reduction targets. There was in fact a good argument that they weren't science-based for many of the targets that have been set. But it failed because law in Australia as it currently stands doesn't provide a real or effective remedy. So the key thing was that the applicants were arguing that the government should have a duty of care under a branch of law called tort law to take care essentially of the Torres Strait Islands by setting appropriate emissions reduction targets and putting in place adaptation measures. And the court said that's not the kind of duty that we can recognise under the law. There has to be legislation for that to be put in place. And so your only remedy really that you have at the moment is the ballot box. That's not a very good finding for these plaintiffs, and it's likely that this decision will be appealed. The judge goes all the way through the argument just in case it's going to be appealed, so there's a lot in the judgment that could possibly, the decisions that the judge makes about the legal position that may be overturned by a future court or reaffirmed. The final case that I wanted to talk to was the case which is a really interesting one. I think Parents for Climate Change against Energy Australia. It was decided, or at least it reached resolution in May 2025. It wasn't a case that was decided by a court. It went to the federal court. There was expert evidence given. The experts, in fact, went into conference and sort of came up with a joint expert report. And shortly after that, the parties agreed to settle. And in settling the case, Energy Australia, which was the defendant in this case, a company that retails gas and electricity, gas and electricity products, agreed that it had misled consumers with a particular product it was marketing called its Go Neutral electricity and gas products. But essentially, when you opted in as an Energy Australia client to these projects, to this product, what would happen is that your fossil fuel use wouldn't be associated with your energy consumption, wouldn't be reduced. Instead, they purchased carbon offsets. But it was said that that was a misleading practice because the idea of go neutral was suggesting that in fact your carbon emissions were being wiped out by the company in selling you this product. In fact, they were using carbon offsets. And there's various elements in the statement that you can look at online where the company agrees that carbon offsets don't actually offset greenhouse gas emissions, and they don't undo or prevent the harms caused by burning fossil fuel. So it's quite a far-reaching decision considering how many companies rely heavily on carbon offsets to meet carbon neutral or net zero targets. It's not a decision of a court, it's a settlement, but the scientific evidence in this case appeared to be so strong that the parties went for a settlement rather than risking, if you like, a judicial decision. And there's more of these cases coming down the line as well. So finally, just look at some of the implications for legal practice, for determining liability, and for scientists. Well, for legal practice, I think one of the interesting things is this emerging reliance on the reports of the Intergovernmental Panel on Climate Change as a kind of baseline for what climate science says on the causes and impacts of climate change. So we saw in early climate cases that there'd be argument about those kinds of issues and in fact challenges to the IPCC reports, but no longer. So you can imagine that this is not going to be something that you have to have extensive expert evidence on in these cases going forward, which might make them a bit cheaper too. You can rely on the IPCC findings. In terms of determining liability, that next stage of can somebody be held responsible, do they pay damages? This is a tricky question because of that nexus element that you have to establish between the harm that's caused and somebody's activity. And causation issues, the IPCC, the ICJ, the International Court of Justice said in its decision, difficult but not impossible. It's hard, but it can be done to prove that. Now, I think a lot of scientists who work in the area of event or source or impact attribution are probably taking that as a challenge now to go forward and produce some of that scientific evidence that could show the evidentiary link. And in fact, there's a couple of recent papers coming out in Nature that are exactly on topic here. So I think because that's sort of the emerging area now, that's where we're going to see a lot of activity around this attribution element, meaning attribution of the harm to a particular actor to determine liability. For scientists, I think scientists remain very essential as expert witnesses in this case. I think this raises all kinds of issues about whether there are sufficient experts, whether we need more capacity building, both of lawyers to understand the scientific evidence, of scientists to understand how to present in these cases, and particularly for our early career researchers. So we don't really have good structures to do that. And generally a need for greater sharing of knowledge across science and legal domains. So this is a really good forum for that. In the Pabai case, the judge actually commented that he found a lot of the scientific evidence very technical. He did seem to be able to digest it, but ultimately he said it was important that the evidence was expressed in simple layperson terms so they could be understood by all, especially with those with a direct interest in the outcome of the case, which in this case were vulnerable communities, Indigenous communities in Torres Strait. So that's also a communication challenge for scientists to ensure that those findings are delivered in ways that can communicate broadly. So that, I think, is my final slide. I've just got one question and discussion. So happy to answer any questions. I've just put at the end, this is our new Laureate program on global corporate climate accountability and where you can find us in terms of the web and email. I'm happy to answer any questions that you might have. I don't know if you're going to moderate them.
Yeah, I'm happy to. Anyone have any questions?
Okay, thank you for the talk. So I'm thinking about other government decisions where what the decision the government makes is going to make some people better off, some people worse off. So thinking something like city council, let's pick on sort of housing as an example, where maybe if the government did more to facilitate the building of more housing, that's going to maybe on average make people better off. It's going to make some people worse off though, even if it, say, lowers the cost for people in the future to live in those places. And then for climate change, right, if the government was to do more to reduce emissions, that's going to maybe make people better off on average in the future, but it's going to make some worse off and some better off. So when I think of litigation around climate change targeting policy, is there anything fundamentally different between the climate change context and any other situation where the government makes policies that are affecting different groups of people in different ways?
Yeah, it's a good question. And I think this came up in the Pabai case in a certain way, to the extent that the court was very clear that it didn't think that the science was the entire standard that needed to be considered. So in a lot of the other policy making contexts, we're also having these similar debates about the extent to which science is important compared to other social considerations. In the climate context, I think it's pretty much the same as the other kinds of settings that you're talking about, but the global dimension gives it a different flavour. So one of the, in some of the other policy-making contexts, the issues will be more intensely local, and there'll sort of be competing interests that you might be looking at particular constituencies played off against each other, maybe temporally dispersed, but probably spatially all in the same kind of area. In the climate context, we're also thinking about that temporal element, so present generations versus future generations, but also the bigger spatial element. So this is a global problem. What are the responsibilities of Australian governments and Australian corporations to do something to address the problem? So that's why that sort of attribution causation issue becomes so important, because that link is much more diffuse in a global context. I think there are similarities, but slightly different global context.
Tanya?
Thank you. Thank you very much. Super interesting. On the question of attribution, my understanding is that most of the cases so far are really focused on failure to transition, so failure to mitigate greenhouse gas emissions. I was wondering, are you beginning to see also cases that revolve around failure to adapt? So there was that famous case of Pacific Gas and Electric in the United States and the fires that were caused as a consequence. I'm assuming that there may come other types of cases where either not only as a result of an event, but also in anticipation?
Yeah, so we're not seeing them as much just yet. I mean, there have been sort of class actions following different events where you get this kind of question, maybe a failure to adapt sufficiently in the planning for water resources or the planning for the placement of electric power lines and their ability to deal with extreme heat, sort of sparked by a particular extreme event. So we're not really seeing them in a proactive sense just yet. I think that the Pabai case was trying to get towards that because one of the arguments was in fact a failure to adapt. Particularly, it sort of boiled it started broader and it boiled down in the end to seawalls and the adequacy of the seawalls. But I think there's a lot more in that area, and this is where you might start to see some kind of sort of convergence between the climate litigation cases that we've seen so far and the debate over loss and damage in the international context. So we haven't quite got there yet. Of course, the question would be, if there's a proactive requirement to adapt, how does that go into climate finance obligations of states? And unfortunately, the ICJ, the International Court of Justice, did reference finance obligations, but didn't say very much about them. Also didn't say very much about adaptation obligations.
It could equally be an aspect of corporate accountability.
It could be an aspect of corporate accountability, and that may be an area where we're going to get more activity. Particularly as we expand beyond sort of the fossil fuel producers as the main targets. So if we're looking at retail firms or agribusiness or other sorts of actors, infrastructure, buildings, then these adaptation questions might be more relevant and go in some ways into the sort of standard planning litigation that we've had for many, many years, which is like if you build things that are not fit for purpose and then they fall down or get subsumed by the seas or they get overwhelmed by coastal erosion, then there's a liability there.
Yeah, you had a point early on about quantification becoming more and more important. And I guess when it comes to things like amenity or culture, maybe you could put a dollar figure on some of those things, but I think you probably can't put a dollar figure on those things in a way that's objectively true. So there's always going to be some kind of intense subjectivity embedded in that. But as soon as you have a dollar figure in front of you, you can kind of easily forget that that's there. And I guess I'm wondering both if like how the courts are approaching that problem, but also if there's other ways around the problem than trying to quantify it.
Yeah, so I'd say that it's at a very nascent stage at the moment. And the Pabai case again doesn't suggest that the courts are quite ready to be able to do some of this valuation. So there was a claim in that case by the plaintiffs that one of the harms they were suffering was to culture and custom. They couldn't use particular areas anymore, that the climate was so changed that their traditional knowledge and ways of being were disrupted and they couldn't pass those on in the same way to future generations. The court basically said, this is not the kind of claim for loss that we can recognise, which sort of suggested that the only sort of thing that they could recognise was something where they could put a dollar value on it. So I think there was quite a limited way of understanding loss and damage, particularly when we look in the international context where they've taken a much broader view. There is some work that was done in the US in particular around contingent evaluation methodologies for trying to get at that question of how much people value things that perhaps not financially quantifiable. But those methodologies also have real problems, and you can imagine that if you had that expert evidence presented in court, it would probably be subject to a lot of varying opinions. The other context we've seen this in New South Wales, the Land and Environment Court has been often involved in a lot of decisions involving coal mines and the effects on local amenity. How's that quantified? The court has sort of got around that by recognising that there can be these amenity and social impacts, and they have to be weighed in the balance with other things without sort of saying, I'm going to weigh it based on economic damage versus or jobs created versus dollar amount. So they've got around it by fudging if you like, it's a balance.
Yes.
Just to follow up on that, I mean, don't courts routinely make awards for things like pain and suffering and other things that are not obviously financially metrosizable? How do they do that? And are there ways that that could be carried over?
Yeah, there's definitely an argument that there's all kinds of things that particularly in personal injury cases that courts do quantify, or they don't quantify, they put a dollar amount on. And if you look at the sorts of judgments that are given, often the amount awarded for pain and suffering varies very widely. In some jurisdictions, they've tried to introduce legislation that gives a dollar amount for particular kinds of injuries. So you lose your arm, it's worth this much to avoid that kind of subjectivity. I don't know if there's a robust scientific methodology underlying that. But
There isn't. I'm wondering about the legal methodology.
Well, the legal methodology where it's sort of set down in legislation is you just have to work out which category it falls into. Otherwise, they do tend to rely on expert evidence to come up with figures.
It would be the actuaries who do that work.
Yeah, it's often based on insurance levels,
Yeah.
if it's personal injury causing particular bodily harms. But you might be talking about, broader pain and suffering. So
Yeah, I might jump in there as a little litigator. Unfortunately, there's no precise assessment that courts make when assessing pain and suffering. It will be informed by whatever evidence is put forward, and they try to come up with some sort of objective amount to compensate for that. But it really is a difficult and challenging area of the law.
it's one of the really interesting differences between scientific decision making and legal decision making in a judicial context. In judicial context, you don't have any option but to deliver a decision. With science, we can always say, well, we're waiting on more evidence, further experiments. Sometimes you don't have to deliver that. Say the methodologies are not there.
So no, it's not a satisfactory outcome.
Not a satisfactory scientific outcome, but it is the legal reality.
Thanks, sorry, yeah,
I just wanted to add to that discussion and say that cultural loss has been recognised as compensable in the native title space. So the Timber Creek case, for example, the High Court was able to quantify and recognise that cultural loss First Nations traditional owners needed to be compensated. And I think the hope in PABI was that the court would come to that similar point in recognising cultural loss as a head of damage in negligence law. But I think Justice Whitney, as a single judge, kind of said, the law doesn't currently say anything about it, and I don't know if it's my place as a single judge to.
I'm not going to go. Yeah. It was a disappointing kind of. There were, as you say, other jurisprudence from other areas that could have been drawn. Also, the way that the judge structured his decision very early on, he kind of said, look, I don't think there's a duty of care. There's no actionable thing here. This is high policy political judgment. And so you lose. But then because probably he's thinking that he's going to be appealed, he goes through the steps of imagining that there is a duty of care, that it's been breached, that he needs to quantify the damage. And so he gives rulings on all of those different aspects. But you can imagine where you're in that sort of hypothetical situation. If they're really hard things, probably it's easier not to rule on them, which may have been the judgment his honour made in that.
Thanks for raising that.
On the comment about going to the ballot box, we're currently in a situation where both of our major parties, the one major party remaining, is not keen on action on climate change really. They're not going to institute any laws that really make it easy for people like the Torres Strait Islanders to in any recompense. and any other parties that would do it are still a long way off. So is that kind of like I don't know, it seems like a farcical comment to make, and I'm wondering if there are other avenues for legal change that are more useful.
There's plenty of cases that have reached an opposite conclusion. In fact, across the Tasman, so New Zealand, where they had a similar case, Smith and Fonterra, involving Maori plaintiffs suing a bunch of companies essentially for the harms caused by climate change to their lands and custom and culture. That hasn't gone all the way through, but the Supreme Court did rule last year that the claims that were being made that there was a common law duty to act were at least arguable. So the case is being allowed to proceed without those arguments just being struck out at a procedural stage. And it may be that it delivers a completely different result from the Australian cases. We've also seen that happen in other jurisdictions around the world, like the Netherlands, for example. So it is perfectly possible for courts to actually say, no, there's a legal issue here and we will render a decision. But some courts take this view that actually this is the domain of policy, the domain of government, it's not the domain of courts, and therefore I'm not going to rule on this issue. And in the Pabai case, the full court of federal court, so the higher court, had already ruled in a case called Sharma that that was exactly the position, that these kinds of questions are public policy questions that are not amenable to courts. So it would have been very difficult for a single judge to go against that decision.
I might just follow up on that point. To what extent do you think the ICJ ruling may have a positive impact on Pabai in the event that the decision is appealed? Given some of the court's comments around almost scaffolding a threshold that governments need to meet when considering taking action on climate change.
Yeah, I've had this discussion with Tomo Boston, in Pabai, that, you know, if issued a couple of weeks later, maybe the court might have taken a different decision. Part of that is because what the International Court of Justice did in its decision was it had quite a lot to say about how the Paris Agreement obligations should be interpreted, including countries' obligations to set emissions reduction targets under their nationally determined contributions. And it made clear that that decision-making process is not a discretionary one. It's not a kind of choose your own special adventure for each country setting an NDC, that there are in fact standards that need to be complied with. And in particular, countries have to have regard to the overall temperature goal, the 1.5 degrees centigrade goal under the Paris Agreement, in looking at the adequacy of their emissions reduction targets. So if you take that finding with the idea that Pabai puts forward, that this is all a matter of high public policy and political judgment, well, you can start to destabilise that finding with the ICJ judgment. In fact, maybe this is, in terms of the Paris Agreement obligations that sit on the Australian government, not a matter entirely in the political realm that could actually be subject to judicial review.
So this is partly circling back to a couple of earlier questions. When I'm thinking about the obligation of governments to maybe act on climate change, there's sort of the issues of the scale of the problem that you've mentioned. And one maybe could think of comparable ones, not quite in scale, but, you know, international fishing or very globalized problems, ozone hole, et cetera. And it seems to me that one thing that in sort of the ethics of how much the world should act on climate change that sets climate change apart is the fact that most of the harms of climate change happen to people who are not yet born. And so does that matter one way or another in thinking about the obligations of government to act? Because I can imagine an argument that, look, things should be resolved at a ballot box if everybody impacted by a decision can vote. That's not the case for climate change. How does that play into the law?
So I think that's still one of these issues that's still being resolved, but it was touched on by the International Court of Justice. It's an equity issue in two different dimensions. There's the equity vis-a-vis future generations, and the court does talk about the principle of intergenerational equity, and that there should be consideration given to, if you like, the rights of future generations. They were asked to rule on that specifically. There's not a lot in the judgment that talks about that. The other aspect, though, where equity is important is it's not just future generations that are most likely to suffer and can't vote, but also particular communities who are going to be impacted and who may have less access to policy-making processes, even if formally there's a democratic right to vote in particular countries like our own. So I think on that aspect, the court did have quite a lot to say about the principle of common but differentiated responsibilities, meaning essentially that developed countries like Australia need to do more, will be held to a higher standard, will be expected to set higher targets to a more stringent standard. There was another international decision released also shortly before the ICJ decision, which was the Inter-American Court of Human Rights. That doesn't apply to Australia, but what was interesting in that case was the court, in talking about human rights obligations and climate change, said that that sort of idea of differentiated responsibilities also applies to companies. So companies that have contributed the most to the problem in terms of the historical and current emissions would be expected to do more. So it's an interesting whether that sort of principle comes across also into the corporate accountability sphere. It's an interesting question. I think unresolved.
We've also got some questions from online. One of them is from David McEwen. Would I have more success if it had commenced after? I think we've kind of touched on that.
I think, yeah,
Um,
possible.
Keen to hear what Jackie thinks about the wording of summary judgment. Was that the negligence law which the case was brought under? Sorry.
Might pass on that one. That looks,
Yeah,
sounds like I need to have seen the question.
I think you need to have seen the question. I think it's more of a comment question.
Yeah, look, one of the things I find with climate law is that it's not really a distinct area of law. It crosses all of these different domains. So people sort of say, what about investment law? What about tort law? All of these things can be part of the actions that we might take. So I'm not a torts lawyer. But what is interesting in the Pavai case is how carefully the judge goes through the requirements to establish a duty of care if you were trying to do that under torts law. So I was kind of thinking, if I did teach torts law, I'd just extract that part of the decision because it would be great for my students to learn about this area of law. But it is a really interesting question in the context of climate litigation because it's sort of asking you to be an expert across so many different avenues of action that could be taken. Essentially the whole gamut of international law and domestic law remedies.
Sort of building on that, I think one of the current challenges we have in Australia is we have a lack of regulation and a lack of law that protects the environment, whereas we see a lot of cases occurring elsewhere in the world where they appear to be a lot more progressive, and I think Australians sort of sit and wonder, why are we having all of these unsuccessful decisions? And it really has a lot to do with our laws and the tools we have available. So essentially the areas of law that we're trying to leverage to put up arguments to sort of progress the law, which is the challenge.
We're missing two key tools in the toolbox. One you might be familiar with, there's debate at the moment about reforming our federal environment laws, which are sort of blind to climate impacts. Be narrowly framed about what needs to be subject to an environmental impact assessment. So Woodside project can go ahead based on the fact that the climate change impacts aren't really considered when a decision is made under our legislation. And the other key tool we're missing is we don't have national human rights protections. So a lot of the cases internationally have been brought on the basis that there's a right to life, or there's a right to health, or there's a right to healthy environment. All of those kinds of things we have in some cases at the state level or the territory level in Australia, but we don't have a national framework that could ground and provide hooks for that kind of litigation.
All right, well, I think we might take a break, and of course, if anyone does have further questions for Jackie, we'll continue the conversation outside with some food. But if I could ask everyone to please join me in thanking